I'm looking forward to giving this presentation, the New York State RAISE Act, the Race for AI Safety Regulation. So I'm looking forward to discussing this new bill, which is also known as AB 6453, and talk about how it's the first kind of regulation setting liability and setting safety guidelines for large developers here, and how it's inspired by other bills, mostly coming from the state of California, such as one that was recently signed into law by Governor Newsom, SB 53. So first I'd like to start off with this page here that you can use this QR code to access different series of links to the different documents that helped me create this presentation, which includes the original text of bills, so that when we're discussing the definitions of different terms of art in the legal world, you can follow along and say, hey, what are the lawmakers, what do they think about qualifies as a large developer? Do I qualify as a large developer? Because the intention of this presentation is to kind of discuss the law and understand how that might affect builders and developers. A disclaimer, nothing in this presentation should be construed as an endorsement, nor is it intended as legal advice. And before we start, I'd like to kind of give a quick overview of how I want this conversation to flow. First, I want to discuss the timeline for the RAISE Act and other similar bills being passed in different states. Then I want to go into a discussion on the policy objectives of the RAISE Act, what it's intending to achieve, and the guidelines that it's setting out to meet compliance standards. Then I want to discuss jurisdictional reach of the RAISE Act, on who this bill is intended to apply for and when does it apply to them. Then I want to discuss the similar situated bill that recently was just signed into law in California, TFAIA, which is SB 53. Then I want to discuss ongoing trends of states regulators outpacing federal regulators. And then we'll finish with some concluding remarks. And of course, a page of legal citations at the end. So first, I want to just show this visual purely for the purposes of showing you how quickly legislation can come into law and be effective. The first bill that you can see here is the Safe and Secure Innovation for Frontier Artificial Intelligence Models Act, SB 1047. That's the bill that failed. That bill was introduced last year in 2024 and was passed by both houses of the legislature in the state of California, and that bill was later vetoed by Governor Newsom because of the outreach of developers and tech companies that reached out to their local elected officials and expressed their opinions on the bill as the language was adopted by the legislatures. The other bills here are bills that have had more success. At the very top, we have the Responsible AI Safety and Education Act, also the RAISE Act, the bill that applies and that will soon apply, hopefully, here in the state of New York, should it continue on its trajectory. Below the bill, SB 1047, is the bill that was just signed into law a few weeks ago by Governor Newsom, SB 53. Then below that is the bill from Texas, Texas Responsible Artificial Intelligence Governance Act, TRIGA, HB 149. What I want to show here and what this visual represents is that none of these bills were officially introduced in their houses' legislatures in the year 2023, but they were being discussed in the background. While lawmakers, by the time lawmakers in the state levels tend to introduce legislation, there usually is a lot of consensus and a lot of history of discussions happening in the background. So even if it wasn't presented to you in the news that there were these bills being signed into law, which the Texas bill was signed by Governor Abbott just this past summer, even if these bills aren't being discussed in the news, they are happening. And I feel that the federal regulations tend to get more attention in the news cycle when really state regulation can be the spearhead for adoption of laws that will then become the norm and then trickle on to federal regulators. The RAISE Act from a policy perspective. The Responsible AI Safety and Education Act, RAISE Act AB 6453, accomplishes two broad policy objectives: outlining duties and liabilities to transparency requirements regarding frontier models and training and use, as expressed in Section 1421 of the Act, and further empowering the New York Attorney General to seek civil actions against large developers in violation of the Act, civil penalties determined by severity of the violation as expressed in Section 1422 of the Act. The Act also goes on into describing different definitions, such as what qualifies as an artificial intelligence model, what qualifies as critical harm. And something that I would like to highlight is an interesting definition that is set there is safety incidents. What qualifies as a safety incident? I'm seeing the trend that other states are adopting similar standards for what qualifies as a safety incident that should be reported to state regulators. So first, the Safety and Security Protocol, which I will refer to as SSPs moving forward. Before deploying any frontier model, the Act sets out that large developers must implement an SSP to prevent critical harms. They must transmit a copy of the SSP to relevant law enforcement agencies. They must also publish a redacted version of the SSP to the general public. Something I'd like to express is that most large developers are already doing this. They're already communicating in the background with their lawyers to different government agencies. Further, several large developers already have some published model of what their internal conduct and training for their AI model looks like. A safety and security protocol broadly sets out standards and for compliance and internal use among staff on how they should behave and interact with the models as they're training and updating them. Further, the Act goes on into setting requirements for third-party audits of the SSP. The SSPs must be designed so that third-party organizations can replicate the safety test and ensure compliance. Lastly, something that's significant is that the Act also sets requirements for disclosing critical safety incidents. Large developers must notify the New York Attorney General and Division of Homeland Security within 72 hours of any critical safety incidents. You can look into the definitions section of the bill to understand what a safety incident is, and something that stood out to me in there is that, and that I'm seeing among other bills, is that something that could qualify as a safety incident is when the AI model acts independently from human input. There's also other concerns that are listed out in the definition of what qualifies as a safety incident, but that's something that stood out to me. Now I'd like to talk about jurisdictional reach of the RAISE Act. What's pictured here is the current New York Court of Appeals, the highest court in the state of New York. The only court that reviews cases past this court is the Supreme Court of the United States. So any piece or dispute in this bill or any other similar situated bill would eventually go to this organization, to this group to decide and figure out the outcomes of any dispute that comes out. So who is intended to fit in this jurisdictional box? The RAISE Act applies at the company level, not at the model level. It exempts every company who has spent less than $100 million cumulatively on computing power to train the biggest AI models. Universities are excluded from the definition of large developers. Legal liability for large developers. Large developers are persons who are trained at least one frontier model. A frontier model is an AI-trained model using 10 to the 26 integer computational power and compute cost that exceeds $1 million. Further, the definition of large developer is expanded to include qualifying distilled models. These are AI models that use distillation methods to train and further develop their AI to become advanced under these new techniques that we have seen recently published. And the monetary input to reach this qualification is less. It's $5 million. SSP mechanisms and associates. Written SSPs are to be published publicly in redacted version, and unredacted versions sent to government agencies. Senior personnel in the large developer organizations are designated as responsible for SSP compliance. This includes the responsibility to report safety incidents. Lastly, actus reus ex machina, which is some fancy legal wordplay, which I'd like to explain very quickly. Actus reus means the guilty act, and ex machina, which I think is a bit more famous, means coming from the machine. So in short, the message is the guilty act that comes from the machine. The critical harms are narrowed to injuries caused by models enabling weapon creation or models that commit crime with no meaningful human intervention. Developers are not responsible for intervening human acts of third parties unless the acts of large developers were substantial in bringing the harms and the intervening act is foreseeable. Now I'd like to talk about the bills in California. Transparency and Frontier Artificial Intelligence Act, SB 53. On September 29, 2025, California Governor Newsom signed into law TFAIA, SB 53, which will be effective as soon as January 2026. The act sets out required frameworks for best practices and mitigate risk. Further, it requires communication and disclosures with California state regulators. An earlier vetoed version of the bill, SB 1047, had some main differences, which included requirements for developers to implement a kill switch, pre-deployment checks, and third-party audits for AI models. It was this earlier bill, SB 1047, which was vetoed in 2024, which had inspired the creation of the New York bill, the RAISE Act. The act sets out, SB 53 sets out penalties for noncompliance. Major broad strokes to look at on how similar SB 53 is to the RAISE Act are risk disclosure requirements. Before deploying models or update models, the act requires conducting catastrophic risk assessments. Qualified developers are required to send results to the California Office of Emergency Services, which moving forward I will discuss as OES. Summaries of any catastrophic risk assessments every 3 months or reasonable schedule as set forth and agreed to by the OES. Safety and incidents disclosure requirements. The act requires qualified developers to notify OES of any critical safety incident within 15 days of discovering the incident, or within 24 hours if the incident presents an imminent risk of death or serious injury. The RAISE Act sets out similar definitions for what it counts as a safety incident, which, among other things, includes the AI acting independently of human input. AI framework disclosure requirements. The Act requires qualified developers to publish publicly on their websites framework disclosures. These framework disclosures are to be uploaded annually and include risk assessments, risk mitigation procedures, and descriptions for training and aspects of developing frontier models. Developers are required to implement and comply with the practices that they themselves set out in their own framework. Now I'd like to discuss the ongoing trends that we're seeing. States are outpacing federal agencies in developing AI regulations. An earlier attempt by the federal government, an attempt to include a federally imposed moratorium on state-level AI regulations failed. 99 senators voting against the moratorium, removing it from the OB3 reconciliation bill earlier this year. This trend is likely to continue. Lastly, with some closing remarks, I look forward to following the regulatory landscape as it continues to change. Further, I'm currently working on some legal scholarship that is covering the intersection between corporate law and AI technology. The tentative title for this legal scholarship that I'm working on is Intelligentia Res Ispa Locator. The publishing is estimated as early as 2026, and the title also goes into some fancy legal wordplay. Res Ispa Locator is a legal doctrine that sets out that the thing speaks for itself. So I kind of just added the word intelligentsia to try and imply the intelligent thing speaks for itself. And I think that kind of hints to my writing, and I look forward to sharing it in future. I'm reachable on LinkedIn, and my X account is Cheggy Counsel. So some citations here. So I promised legal citations, and here they are, which includes the citations for the legislation, further articles that were used in developing the writing, and also I made some citations for where I sourced the pictures. I was trying to source some pictures from National Geographic, but I couldn't find a gaggle of senators to use as a picture. So hopefully they can work on that and develop there. So thank you.